Hello and welcome viewers, you're watching our brand new show In Depth with your host Kriti Mishra, a platform where we break the most complex issues of the world and our country in just 5 simple questions and their 5 simple answers and help you understand how these issues matter to you. For the last few days, the Supreme Court's Constitution Bench is hearing a batch of petitions challenging the constitutional validity of reservation for economically weaker sections of citizens. So what is reservation? Well, the age-old caste system of India is responsible for the origination of the reservation system in the country. In simple terms, it is about facilitating access to seats in government jobs, educational institutions, and even legislatures to certain sections of the population. These sections have faced historical injustice due to their caste identity. In India, it is governed by government policies backed by the Indian Constitution. Reservations were initially introduced for a period of 10 years and only for SCs and STs, but it kept on extending with several changes in it. So what is the historical background of reservation? Well, the Constitution of India has secured the first fundamental right to the people of India, that is Article 14, which is right to equality. Article 15 is strictly titled as prohibition of discrimination on grounds of race, religion, caste, sex, or place of birth. But the idea of reservation was introduced and founded by William Hunter and Jyotirao Phule in 1882. In 1902, Sahu Maharaj of the princely state of Kolhapur introduced the reservations in favor of the non-Brahmin caste for education. Mysore and the princely states of Travancore and Kochi also supported his idea. After long negotiations, Mahatma Gandhi and B.R. Ambedkar signed the Pune Pact, where it was decided that there would be a single Hindu electorate with certain reservations in it. After independence, initially reservations were provided only for SCs and STs, and OBCs were included in the ambit of reservation in 1991 on the recommendations of the Mandal Commission. So what was the role of the Mandal Commission? Well, in exercise of the powers conferred by Article 340 of the Constitution, the President appointed a backward class commission in December 1978 under the chairmanship of B.P. Mandal. The Mandal Commission concluded that India's population consisted of approximately 52% OBCs, therefore 27% government jobs should be reserved for them. The Commission has developed 11 indicators of social, educational and economic backwardness. Apart from identifying backward classes among Hindus, the Commission has also identified backward classes among non-Hindus like Muslims, Sikhs, Christians and Buddhists. It has generated an All India Other Backward Classes list of 3,743 castes and a more underprivileged depressed backward classes list of 2,108 castes. So what are the different categories for reservation? Well, as per extant instructions, reservation is provided to scheduled castes, scheduled tribes and other backward classes at the rate of 15%, 7.5% and 27% respectively in case of direct recruitment on all India basis by open competition. With the enactment of the Rights of Persons with Disabilities Act of 2016, reservation is also provided to persons with benchmark disabilities against the posts and services of the central government at 4%. Recently, the Constitutional 103rd Amendment Act of 2019 has provided 10% reservation in government jobs and educational institutions for the economically backward in the unreserved category. The Act amends the Article 15 and 16 of the Constitution by adding clauses empowering the government to provide reservation on the basis of economic backwardness. So what are the judicial pronouncements? Well, in the Indira Sahani case of 1992, the Supreme Court, while upholding the 27% quota for backward classes, struck down the government notification reserving 10% government jobs for economically backward classes among the higher castes. The Supreme Court in the same case also upheld the principle that the combined reservation beneficiaries should not exceed 50% of India's population. However, the judgment itself said that in exceptional circumstances, the percentage can be increased. And I will end this edition with a quote from Dr. B.R. Ambedkar. Slavery does not merely mean a legalized form of subjection. It means a state of society in which some men are forced to accept from others the purpose which control their conduct. Unquote. I'll leave you with those thoughts. Goodbye for now.